The U.S. Supreme Court ruled against freezing the $2 billion in foreign aid funds. You want to talk about that a little bit? So they basically undid what they did last week. And what I predicted last week was not what they did. So that's what you get when you count on Roberts and Barrett. You get screwed a bunch of the time. So yeah, basically the administrative stay last week ended up being like, psych, because a few days later they changed their mind. So we're going to talk about that case. I won't be repeating a lot of what I said last week. So if you want to watch last week's video, I have a lot of the background in that. This week we're really just going to focus on the Supreme Court's decision and a lot of the dissent. And the dissent was correct in my view. So anyway, we're going to talk about that. The caption here is the Department of State. It's the one with Judge Ali and the $2 billion in foreign aid funds. But it's Department of State et al. Versus AIDS Vaccine Advocacy Coalition on the application to vacate the order issued by the district court judge. So that is the case we're going to be talking about. Just to refresh your memory on the timeline, this is basically the same as it was last week, but we've added a new date at the bottom. So you can see this all started on January 20th with the executive order. Then you see the lawsuit, Judge Ali issuing the TRO, and then demanding that the president pay it by midnight. The DC Circuit punting the Supreme Court. Roberts on February 26th issuing an administrative stay on the TRO. Got me excited, thinking maybe they're going to do what's right. And then a few days later, the Supreme Court in the 5-4 decision denied the application. So this is basically what we're going to be talking about, is that decision on March 5th. So if you look at those dates, though, you can kind of just see it was only a few days later when the Supreme Court changed their mind, when Judge Roberts changed his mind. So looking at the end of February, Chief Justice Roberts was saying, should I stay the order? All signs point to yes. Only to completely reverse it a few days later? Absolutely. Let's do that. Here is the majority opinion, all of it. The unhighlighted portion basically is just showing the facts of the case up to this point. So the real only meat, and this isn't even meat, it was really procedural, but the only thing the majority really said was what I have highlighted, and I thought we'd read it here just so we could talk about it. The Chief Justice entered an administrative stay shortly before the 11:59 p.m. deadline and subsequently referred the application to the court. The application is denied. So we changed our minds. Given that the deadline in the challenge order has now passed, and in light of the ongoing preliminary injunction proceedings, the district court should clarify what obligations the government must fulfill to ensure compliance with the temporary restraining order, with due regard for the feasibility of any compliance timelines. The order heretofore entered by the Chief Justice is vacated. You got to give him solid points for heretofore. It's a good use of heretofore. But anyway, that is basically the entirety of what the majority said. What the majority didn't say, that we all want to know, is what happened to Roberts between February 26th and March 5th for him to completely change his mind. I mean, the only thing I could think of is if he was forced to go through a Rachel Maddow marathon without any bathroom breaks. I mean, maybe that would have made him crack and he changed his mind, but I really would like to know what happened that made you decide to change. I think we can learn a few things from the majority opinion. One, they refused to stay the TRO, which means they didn't really agree with the TRO necessarily. They just refused to touch it. So that doesn't mean they substantively agreed with it. In fact, it means they really didn't, because they basically just left it untouched, and the majority opinion is purely procedural. So it doesn't mean they agreed with Judge Ali. That's one thing we can take from it. It was an unsigned opinion. So unsigned opinions, that's basically, like the Supreme Court doing the old anonymous has left the chat, and you wondered who it was. Anyway, no. So unsigned opinions, it could mean a few things. It doesn't necessarily mean that in this case, but I'm just going to give you some different things that I think it could mean. It could mean that there was a lack of strong consensus among the five. That could be why it was unsigned. There could be some kind of discomfort in the majority or uneasiness with what they were doing, wanting to be more hands-off on, we're really not going to look too closely at this, we're not going to sign the opinion. Most likely the unsigned nature of this just means that it was purely procedural, definitely not any kind of major precedent. But I still think some of those other factors could have come to play on that being unsigned. 3, the unsigned opinion might signal that even the majority wasn't fully convinced of their own decision. Not necessarily, but maybe. I'm trying to give myself some hope that maybe Roberts and Barrett weren't completely insane. So maybe they were a little uncomfortable with it. It might be stretching it a little, but still, maybe that's why it was unsigned. But they did have one line in that majority opinion. They said, with due regard for the feasibility of any compliance timelines, which I think was a gentle reminder from Roberts and the court that President Trump is the President of the United States. With due regard for the feasibility of any compliance timelines, give him a little bit of leeway here. He's the president. Still, very lame. They should have said a lot more than that. I feel like the majority was completely wrong, but I think that statement in it was kind of a little, watch yourself, just from the majority, because they did throw that in this purely procedural opinion. Now let's get on to the dissenting opinion. Here's where things get pretty interesting, okay, because they signed their opinion and they had some things to say. They were ticked, if you can read through the lines here. So this was Justice Alito with Thomas, Gorsuch, and Kavanaugh. And let's just read this opening paragraph. Does a single district court judge who likely lacks jurisdiction over the unchecked power to compel the government of the United States to pay out and probably lose forever $2 billion taxpayer dollars? The answer to that question should be an emphatic no, but a majority of this court apparently thinks otherwise. I am stunned. When Alito says I am stunned, in legalese that basically means WTF. That's what that means. You've got a Supreme Court justice with decades of experience being stunned. That's like a surgeon being in the middle of a surgery and saying, I've never seen this before. Yeah, and it's really bad. Okay, so definitely Alito was very unnerved by what the majority just did. Before we dig into the dissent and their specific arguments, just some general things about the dissent. I mentioned earlier, Alito, Thomas, Gorsuch, and Kavanaugh, they dissented with a signed opinion. They wanted their objections on the record because they saw the majority decision as deeply flawed. You can tell that from reading their dissent. And also keep in mind that you only need 4 justices to grant certiorari, to grant review. So I feel like there's a 99% chance that this case is coming back because these 4 justices are chomping at the bit to fix this, and they're definitely going to be granting review. You've got the 4 votes to get review when this comes up again. So that's what we're looking at here, I think. These 4 justices signed their opinion because they wanted future generations to know that at least 4 Supreme Court justices knew what the separation of powers was. They wrote a legal argument in the dissenting opinion, and the majority basically said, pass. The dissent laid out why they thought the majority was wrong. They thought that Judge Ali overstepped his authority. They said a single district judge should not have the unchecked power to force the U.S. government to pay $2 billion. No duh, okay? And then B, they did call it an act of judicial hubris that violated sovereign immunity and the separation of powers. Now, when Alito says that this district judge had a case of judicial hubris, he wasn't saying that he disagreed with him. He was saying you have a terminal case of who do you think you are syndrome. This was Alito's way of basically telling this judge, someone needs to remind you what floor of the courthouse you work on. And the term judicial hubris is about 2 inches away from saying you have a God complex. I mean, it's this close, okay? Very close. The dissent also pointed out why the district court was legally flawed. The judge labeled his order as a TRO to block appeals, but it was actually a mandatory injunction forcing irreversible action. And I did talk about that last week on my video. Anyway, that was one of the reasons. TROs are meant to temporarily preserve the status quo, not force irreversible payments. The dissent was not buying at all that this was a temporary restraining order, because it wasn't temporary. So either this district court judge really doesn't know what temporary means, or he just thought that we're all dumb enough to believe him when he says it, right? Or he just thought that the district court, that the DC Court of Appeals would go, okay, we believe you. The DC Circuit Court of Appeals failed in their duty. The appellate court wrongly dismissed the case, claiming that it lacked jurisdiction over the TRO. Because it wasn't temporary, they should have reviewed it, but they didn't. The dissent pointed out that this was an abuse of procedure. And in parentheses at the bottom, I am wondering, was this designed to shield the lower court's ruling from proper review? Like, did the district court judge say, I'm going to call it temporary to make this judicial review proof? Is that good with you? And then the DC Circuit Court of Appeals said, well, that works for us because we don't like Trump anyway. This will be fantastic. You call it temporary and we'll say, okay, we didn't know what that big word meant, but we'll believe you. The DC Circuit Court of Appeals refusing to exercise jurisdiction over that and to review this TRO, that's like somebody saying, oh, I can't make that call right now because my phone is dead. And you can literally see the screen on and that they're on some OnlyFans page, but you just go along like, oh, okay, yeah, your phone's dead. That's basically what happened. The dissent also pointed out that the Supreme Court's inaction is allowing this unlawful ruling to stand. The Supreme Court should have stepped in to stop the payment, but the majority refused. Alito warned that this ruling creates a dangerous precedent where judges can force executive action without proper review. Thanks to this ruling from the Supreme Court, district court judges across the country have now updated their LinkedIn profile to read Executive Branch Manager. Progressive judges across the country are now thinking that this separation of powers from the Constitution is more of a suggestion, really, not necessarily a legal framework, thanks to this decision. I think there's probably 50 or 60 cases like this where district court judges are trying to stop President Trump from being the president. And after this decision, there's probably going to be 500 soon. Basically, this decision says, hey, you progressive judges, go ahead, knock yourselves out. Pretend you're president. The dissent also emphasized that once the money is dispersed, it will be impossible to claw back. Alito said this, the government has represented that it would probably be unable to recover much of the money after it is paid. The government trying to recover this money after it has been paid would be like trying to unscramble an egg, with the additional complication that the egg has been shipped to 47 different countries. I don't know what was happening on this case, to be honest. The majority was acting like a teenager with their first credit card where they don't know how it works. Like, it doesn't matter how much it costs. We'll deal with that later. Let's just do it. Alito also criticized the majority for failing to fulfill the court's duty to ensure judicial power is not abused, noting that the court has a responsibility to review lower court orders that may exceed proper authority, so that they can rein in activist judges. Otherwise, you're going to encourage more. Now, the parentheses I added to just kind of give a practical, this is why you'd want to do that. But of course, you have to do that. Alito and the dissent concluded that the court's ruling imposes a $2 billion penalty on taxpayers for no legitimate reason, which is crazy. The Supreme Court needed to get these district judges in line with this opinion, and they did not. It reminded me of when I was younger, my dad taught 8th grade. So he taught U.S. history. And he had a technique where at the beginning of the year, he was super strict at the beginning of the year, to the point where the kids were just scared almost. But he said he did that because it would make the kids behave and be, a really good classroom with order throughout the year if he set the standard at the beginning that these are the rules and you need to keep them, you need to keep your nose clean and not get in trouble. That's why he did that. That is what the Supreme Court should have done right here, because we've got Trump is in office, all these district judges are basically all these crazy progressives thinking, what can they get away with? And instead of trying to teach them a lesson on what to do, the district court said, do what you want, kids. Basically, the Supreme Court created 500 district court judges out there who are just like the kid who makes fart noises the first few days of class, and nobody stops him. And so guess what? Now he's a one-man orchestra, only we've got 500 of them. Just a few final thoughts here. I think that reviewing the TRO probably caused some hesitancy by Roberts and Barrett. They were thinking this is a TRO, we're not supposed to be able to review it because it's temporary. And I think that may have been one of the reasons why it gave them pause to not want to do anything with it. They were wrong. I think they were totally wrong, but I'm thinking that's probably one of the reasons why they just like, let's leave it alone. He's saying it's temporary and let's believe him. But again, I think they're wrong. It also is very early in this case and the facts are not really clear yet. So that also could have given pause to Roberts and Barrett. I'm trying to give a little bit of the benefit of the doubt to Roberts and Barrett here. So maybe they also wanted to see more of the record filled out so that they knew more facts and they were a little bit more agreed on what was going on before they actually made a decision and did something with it. But again, I said this earlier, but I do think this case will be coming back to the Supreme Court because it only takes 4 justices to grant review. And those 4 judges who dissented are clearly going to want to review this again and try to fix it. I don't even know if I should make a prediction again because the one I made last week was completely wrong. But I really hope that when this comes back, Roberts and Barrett will step up and do the right thing and slap this district court judge down and make clear that, look, the president is the president. He has to be able to act like the president, and you cannot be directing what he does. I hope they do that. They screwed me last week, so anyway, we'll watch it, and I'll keep you updated. I'll kind of keep watching in this case. So thank you for watching. Thanks for watching Headlines and my YouTube Shorts. Have a great weekend, and we will see you next week.